गुड मॉर्निंग फ्रेंड्स, आप सबों का बहुत बहुत अभिनंदन है। कहा जाता है कि तकदीर के दरवाजे की सिर्फ एक ही चाबी है, जिसे मेहनत और परिश्रम कहा जाता है। इसी बेहतर कोटेशन के साथ मैं आप सबों का बहुत बहुत अभिनंदन करता हूं। आज का जो प्रश्न होगा पॉलिटी सेक्शन से होगा, बहुत ही मज़ेदार सेक्शन होगा। बने रहिए इस चैनल में, देखते रहिए, सीखते रहिए, आगे बढ़ते रहिए। ऑल द बेस्ट फॉर योर अपकमिंग एग्जाम। पहला प्रश्न पर आपको विचार करना है दिए गए कथनों पर। High Court has a original jurisdiction regarding dispute relating to the election of the members of the parliament and the state legislature. High Court has the original and exclusive jurisdiction regarding enforcement of the fundamental rights of citizens. The read jurisdiction of the High Court is concurrent with the read jurisdiction of the Supreme Court. दो स्टेटमेंट गलत है, बाकी दोनों स्टेटमेंट 1 और 3 सही है। देखिए ओरिजिनल जुडिक्शन क्या होता है हाई कोर्ट का। सिंपल अर्थ है पावर ऑफ अ हाई कोर्ट टू हियर disputes in the first instances. First instances, not by way of appeal, not by way of appeal. It extends to the following. Let's see. Matters of admiralty and contempt of court. Dispute relating to the election, the members of the parliament and state legislature regarding revenue matter or an act, order, or in done in revenue collection, enforcement of fundamental rights of citizens, cases, cases ordered to be transferred from a subordinate court involving the interpretation of the constitution to its one file. The four high court, Calcutta, Bombay, Madras, or Delhi High Court, have original jurisdiction in cases of higher value. Before 1973, the Calcutta, Bombay, and Madras High Courts also had original criminal jurisdiction. This was fully abolished by the Criminal Procedure Code 1973. Read Jurisdiction of High Courts. Article 226 of the Constitution empowers a High Court to issue writs including habeas corpus, mandamus, certiorari, prohibition, and quo warranto for the enforcement of the fundamental rights of the citizen and for any other purpose. The phrase "for any other purpose" refers to the enforcement of an ordinary legal right. The High Court can issue writs to any person, authority, and even government, not only within its territorial jurisdiction but also outside its territorial jurisdiction, if the cause of action arises within its territorial jurisdiction. Read jurisdiction of the High Court under Article 226 is not exclusive but concurrent with the read jurisdiction of the Supreme Court under the Article 32. It means when the fundamental rights of the citizen are violated, the aggrieved party has the option of moving either the High Court or Supreme Court directly. However, the read jurisdiction of the High Court is wider than that of the Supreme Court. This is because the Supreme Court can issue writs only for the enforcement of the fundamental rights, not for any other purposes. That is, it does not extend to a case where the breach of an ordinary legal right is alleged. With the reference to the judicial review, consider the following statement. The power of judicial review on the Supreme Court and the High Court is conferred by the Constitution. Power of judicial review on the judiciary is the basic feature of the Constitution. बी ही सही है केवल कि दोनों सही है? दोनों सही दिया हुआ है यहाँ पर, करेक्ट। देखिए जुडिशियल रिव्यू इज द पावर ऑफ द जुडिशरी टू एग्जामिन द कॉन्स्टिट्यूशनलिटी of the legislative enactment and the executive orders of both the center and state government. On examination, if they are found to be violative of the constitution, they can be declared as illegal, unconstitutional, and invalid, null and void by the judiciary. Consequently, they can not be enforced by the government. The doctrine of judicial review originated and developed in the USA. It was pronounced the first time in a famous case, Marbury versus Madison, 1803, by the John Marshall, the Chief Justice of American Supreme Court. In India, on the other hand, the Constitution itself confers the power of judicial review on the judiciary, both the Supreme Court as well as High Court. Further, the Supreme Court has declared the power of judicial review as a basic feature of the Constitution or an element of the basic structure of the Constitution. Hence, the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. But I think there is no mention anything about judicial review in such a constitution. ऐसा कोई एक्सप्लिसिट मतलब बताया नहीं गया है. ठीक है, हालांकि कई जगह जुडिशियल रिव्यू जैसा व्यवहार दिखता है, बट जुडिशियल रिव्यू जैसा कोई संविधान में शब्द नहीं है. Which of the following articles explicitly confer the power of judicial review of the Supreme Court and the High Courts? Article 13, Article 133, Article 246. Only and only 1, 2, and 3. All are correct. Following article explicitly confirm the power of judicial review on the Supreme Court and the High Courts. Article 13 declares that all laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. Article 32 guarantees the right to move the Supreme Court or court for the enforcement of the fundamental rights and empowers the Supreme Court to issue direction or orders or writs for the purpose. Article 131 provides for the original jurisdiction of the Supreme Court in central state and interstate disputes. Article 132 provides for the appellate jurisdiction of the Supreme Court in the constitutional cases. Article 133 provides for the appellate jurisdiction of the Supreme Court in civil cases. Article 134 provides for the appellate jurisdiction of the Supreme Court in criminal cases. Article 134A deals with the certificate for appeal to the Supreme Court from the High Courts. Article 135 empowers the Supreme Court to exercise the jurisdiction and the powers of the federal court under any pre-constitutional law. Article 136 authorizes the Supreme Court to grant a special leave to appeal from any court or tribunal except military tribunal or court martial. Article 143 authorizes the President to seek the opinion of the Supreme Court on any question of law or fact or any pre-constitutional legal matters. Article 226 empowers the High Courts to issue direction or orders or writs for the enforcement of the fundamental rights and for any other purposes. Article 227 vests in the High Courts the power of the superintendence over all courts and tribunals within their respective territorial jurisdiction, except military courts or tribunals. Article 245 deals with the territorial extent of law made by the Parliament and by the legislature of the states. Article 246 deals with the subject matter of laws made by the Parliament and by the legislature of the states, union list, state list, concurrent list. Article 251 and 254 provides that in the case of the conflict between the central law and the state law, the central law prevails over the state law and the state law shall be void. Article 372 deals with the continuance in the force of the pre-constitutional laws. Consider the following statement. Concept of judicial activism originated and developed in UK. Concept of public interest litigation is a product of judicial activism. B is the right answer. Judicial activism denotes the proactive role played by the judiciary in the protection of the rights of the citizen and in the promotion of the justice in society. In other words, it implies the assertive role played by the judiciary to force the other two organs of the government, legislature and executive, to discharge their constitutional duties. The concept of the judicial activism originated and developed in the USA. In India, the doctrine of judicial activism was introduced in mid 1970s, Justice V.R. Krishna Iyer, Justice B.N. Bhagwati, Justice O. Chinnappa Reddy, Justice D.A. Desai led the foundation the justice judicial activism in country. Judicial activism in a way of exercising judicial power that motivates judges to depart from normally practiced strict adherences to the judicial precedents in the favor of the progressive and new social policy. It is commonly marked by decision calling for the social engineering, and occasionally these decisions represent intrusion in the legislative and executive matters. The concept of the public interest litigation (PIL) originated and developed in USA in 1960s. In India, the PIL is the product of judicial activism role of the Supreme Court. It was introduced in early 1980s. Justice V. R. Krishna Iyer, Justice P. N. Bhagwati were the pioneers of the concept of the PIL. Under the PIL, any public spirited citizens or social organization can move the court for the enforcement of the rights of any person or groups of a person who, because their poverty or ignorance or social or economically disadvantaged position, are themselves unable to approach the court for the remedies. Thus in a PIL, any members of the public having sufficient interest can approach the court for enforcing the rights of the other person and redressal of common grievances. Petition falling under which of the following categories can be entertained as a public interest litigation? Petition regarding admission to medical institution, no payment of minimum wages to workers, petition against police for refusing a register a case. एट ऑब्सोल्युटली इनकरेक्ट है, दो और तीन सही है. देखिए स्कोप ऑफ पब्लिक इंटरेस्ट लिटिगेशन PIL in 1998 the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petition received by the PIL. These guidelines are modified were modified in 1993 and 2003 according to them letters or petition falling under the following categories alone will ordinarily be entertained as a PIL. Bonded labor matters, neglected children, non payment of minimum wages to workers, and exploitation of casual workers, and complaints of violation of the labor laws, exception in individual cases. Petition from jail complaining of harassment for premature release and seeking release after having completed 14 years in a jail, death in jail, transfer, release of on personal bond, speedy trial as a fundamental right, petition against the police for refusing to register a case, harassment by police and death in the police custody, petition against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, petition complaining of the harassment or torture of a villager by co-villager or by police from person belonging to the scheduled caste, scheduled tribes, and economically backward classes, petition pertaining to the environmental pollution, disturbances of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antique forest and wildlife, and other matters of public importance. Petition from riot victims, family pension. The case falling under the following category will not be entertained as a PIL. Landlord tenant matters, service matter, and those pertaining to the pension and gratuity, admission to medical and other educational institution, petition for early hearing of cases pending in high courts and subordinate courts. Consider the following statements. A person to be appointed as a district judge should have been an advocate or a pleader for 10 years. The control over district courts and other subordinate courts is vested in the Supreme Court of India? No. इन ये दोनों गलत है. Let's see Article 220, 233 to 237, 233 से 237 in Part 6 of the Constitution make the following provision to regulate the organization of a subordinate courts and to ensure their independence from the executive. Let's see one by one. सबसे पहले appointment of district judges. The appointment, the posting, the promotion of the district judges in a state are made by the governor of the state in consultation with the High Court. A person to be appointed as a district judge should have the following qualification. He should not already be in a service of the central or state government. He should have been an advocate or a pleader for the 7 years. He should be recommended by the High Court for their appointment. Control over subordinate courts. The control over the district courts and the other subordinate courts, including the posting, promotion, leave of person belonging to the judicial services of state, and holding any post inferior to the post of the district judges is vested in the High Court. Consider the following statement. District judges possesses original and appellate jurisdiction in both the civil as well as the criminal matters. The Chief Judicial Magistrate has the power to impose any sentence, including the imprisonment and the capital punishment. Yes, A is statement correct. Subordinate court, सेशन कोर्ट को पावर है क्रिमिनल वाला एक्टिविटी के लिए. The organizational structure, jurisdiction, and the nomenclature of the subordinate judiciary are laid down by the states. Hence, they differ slightly from the state to state. The district judge is the highest judicial authority in the district. He possesses original and appellate jurisdiction in both civil as well as criminal matters. In other words, the district court and district judge is also the session judge. When he deals with civil cases, he is known as the district judge. When he hears the criminal cases, he is called session judge. District judges exercise both the judicial and administrative powers. He also has supervisory powers over all the subordinate courts in their districts. Appeals against his orders and judgments lie to the high courts. The session judge has the power to impose any sentence, including life imprisonment and the capital punishment, death sentence. However, a capital punishment passed by him is subject to confirmation by the high courts whether there is an appeal or not. Below the district court and the session courts, below the district court and session court stands the court of subordinate judge on the civil side and the court of chief judicial magistrate on the criminal side. The subordinate judges exercise unlimited pecuniary jurisdiction over civil suits. The chief judicial magistrate decide criminal cases. Chief judicial magistrate decide criminal cases which are punishable with the imprisonment for a term of up to 7 years. At the lowest level on the civil side, the court of munsi, and on the criminal side is the court of judicial magistrate. The munsi possesses limited jurisdiction and decides civil cases of small pecuniary stake. The judicial magistrate tries criminal cases which are punishable with the imprisonment from up to 3 years. Next question about Election Commission of India. Chief Election Commissioner has deciding vote in case of the differences of the opinion amongst the chief election commissioner and other election commissioner. The chief election commissioner and the other election commissioner hold office till the pleasure of the president. The constitution has not debarred the retiring election commissioner from any further appointment by the government. Only three is the right. The, the election commission is a permanent and independent body established by the Constitution of India directly to ensure free and fair election in country. The chief election commissioner and the other two commissioner have equal powers and receive equal salary, allowances, and other services which are similar to those of a judge of Supreme Court in case of differences of opinion amongst the chief election commissioner and other two election commissioner. The matter is decided by the commission by majority. Chief election commissioner is provided with the security of tenure. He cannot be removed from his office except in the same manner or same grounds as a judge of the Supreme Court. In other words, he can be removed by the president on the basis of the resolution to that effect by both the houses of the parliament with a special majority, either on the ground of proved misbehavior or incapacity. Thus, he does not hold his office till the pleasure of the president, though he is appointed by him. Though the constitution has sought to safeguard and ensure the independence of the institution and impartiality of the election commission, some of the flaws can be noted here. Like the constitution does not prescribe the qualification, the legal, the educational, the administrative, or the judicial, the members of the election commissioner or election commission. Constitution has not specified the term of the members of the election commission. The constitution has not debarred the retiring election commissioner from any other further appointment by the government. Article 324 of the Constitution provides the Election Commission the power of superintendence, direction, and control of election to Parliament of India, Office of Vice President, Office of Governor. Shape 1 and 3 is the right answer. Article 324 of the Constitution provides the power of the superintendence, direction, control of election to the Parliament, State Legislature, Office of the President of India, Office of the Vice President of India shall be vested in the Election Commission. Thus, the Election Commission is an all India body in the sense that it is common both the central government and the state government. The Election Commission is not concerned with the election to the panchayat or municipalities in states. For this, the Constitution has also provides a separate state election commission. Governor is neither directly elected by the people nor indirectly elected by the specially constituted electoral college as in the case with the president. He is appointed by the president by warrant under his hand and seal. Consider the following. Article 284 of the Constitution of India provides for a finance commission. The Constitution authorizes the president to determine the qualification of the members of the finance commission and manner in which they should be selected. Finance Commission makes recommendation to the President of India regarding principle that should govern the grant in aid to the states out of contingency fund of India. बहुत ही सिंपल प्रश्न है, चलिए इसका सही जवाब बी है, केवल दो सही है. आर्टिकल 280 of the Constitution of India provides for a finance commission and a quasi judicial body. It is constituted by the President of India every fifth of the year or at such earlier time as he considered necessary. Finance Commission consists of a chairman and four other members to be appointed by the President. They hold office for such period as specified by the President in his order. They are enforceable, they are eligible for reappointment. The Constitution authorizes the Parliament to determine the qualification of a members of the Commission and the manner in which they should be selected. Accordingly, the Parliament has specified the qualification of the chairman and the members of the Commission. The chairman should be a person having experience in public affairs, and other four members should be elected from among us the following: a judge of the High Court or one qualified to be appointed as one, a person who has specialized knowledge of finance or accounts of the government, person who has wide experience in the financial matters and in administration, a person who has a special knowledge of economics. A finance commission is required to make recommendation to the President of India on the following matters: the distribution of net proceed of taxes to be shared between the state, between the center, and the allocation between the states, the principles that should govern the grants in aid to states by the center out of the Consolidated Fund of India, the measures needed to augment the Consolidated Fund of State to supplement the resources of the panchayat and the municipalities in the state or on the basis of the recommendation made by the State Finance Commission. Any other matter referred to it by the President in the interest of sound finance. With the references to the Goods and Service Tax Council, consider the following statement. Article 279A empowers the President of India to constitute a GST Council. Every decision of the Council is taken by a majority of not less than two-thirds of the weighted votes of the members present and voting at the meeting. The quorum for conducting a meeting of the GST Council is one half of the total numbers of the members of the Council. 1 and 2 and 1 and 3, only 1 and 3, 75% चाहिए किसी चीज को पास करने के लिए. 101st Amendment Act 2016 paved the way for the introduction of a new tax regime, GST, in country. The amendment inserted a new Article 279A in the Constitution. The article empowered the President to constitute a GST Council by an order. Accordingly, the President issued the order in 2016 and constituted a council. The decision of the council are taken at its meeting. One half of the total numbers of the member of the council is the quorum. One half. Always remember, one half of the total members of the council is required for quorum for conducting a meeting. Every decision of the council is to be taken by the majority not less than three-fourths of the weighted votes of the members present and voting at the meeting. The decision is taken in accordance with the following principle. The vote of the central government shall have a weightage one-third of total votes cast in that meeting. The votes of the all state government combined shall have weightage of the two-thirds of the total votes cast in that meeting. With the reference to the special officer for linguistic minorities, consider the following. Part 18, Part 18 of the Constitution of India provides for a special officer for linguistic minorities. He hold office for a term of 6 years or until they attain the age of 65 years, which is earlier. I think both the statements are incorrect. Originally, the Constitution of India did not make any provisions with special report about special offer for linguistic minority. लेकिन 7th Constitutional Amendment Act 1956 inserted a new article, Article 350B in Part 17, 17, Bhag 17 of the Constitution. This article contained the following provision. There should be a special officer for linguistic minorities. He is to be appointed by the President of India. It would be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under the Constitution. The Constitution does not specify the qualification, tenure, salary, allowances, service condition, and procedure for the removal of the special officer for linguistic minorities. With the reference to the Comptroller and Auditor General of India (CAG), consider the following statement. CAG holds office for a period of 6 years or up to the age of 65 years, whichever is earlier. The salary of the CAG is equal to the Chief Justice of High Court. It's the duty of the CAG to uphold the Constitution of India. Yes, 1 and 3. Constitution of India, Article 148, provides the independent office of Comptroller and Auditor General of India (CAG). He hold office for a period of 6 years or up to the age of 65 years, whichever is earlier. He can resign anytime from his office by addressing the resignation letter to the President. He also be removed by the President on the same grounds and in the same manner as a judge of the Supreme Court. To ensure the independence of the CAG, his salary and other service conditions that are determined by the Parliament, his salary is equal to that of a Chief Justice of the Supreme Court or the Chief Judge or the judges of the Supreme Court. Neither his salary nor his rights in the respect of leave of absence, pension, or age retirement can be altered to his disadvantage after his appointment. CAG is guardian of the public purse and controls the entire financial system of the country at both the state level as well as central level. His duty is to uphold the Constitution of India and laws Parliament in the field of the financial administration. He is one of the back bulwark of the democratic system of the government in India. The others being the Supreme Court, the Election Commission, the Union Public Service Commission. Consider the following. CAG exercises control over the issue of money from Consolidated Fund of India. CAG audits all expenditure from the contingency fund of each state and the public account of each state. How can you say both are statement? Only two is right. Audits and the function of the CAG are laid down by the Parliament and the Constitution are. He audits the accounts related to expenditure from Consolidated Fund of India, Consolidated Fund of each state, and Consolidated Fund of each UT having a legislative assembly. The audit of all expenditure from Contingency Fund of India and the Public Account of India, as well as the Contingency Fund of each state and the Public Account of each states. He advises the President with regard to the prescription of the form in which the accounts of the center and the state shall be kept. He ascertain and certifies the net proceed of any tax or duty. His certificate is final. The net proceeds means the proceeds of a tax or a duty minus the cost of collection. He acts as a guide, friend, philosopher of the public account Committee of the Parliament. CAG submit three audit reports to the Parliament, to the President, audit audit report on appropriation account, audit report on finance account, audit report on public undertaking. The President lays these reports before both the House of the Parliament. After this, the Public Account Committee examine them and reports its finding to the Parliament. The Constitution of India visualizes the CAG to be comput- comptroller as well as the Auditor General. However, in the practice, the CAG is fulfilling the role of the Auditor General only and not that of the comptroller. In other words, the CAG has no control over the issue of money from the consolidated fund, and many departments are authorized to draw money by using checks without specific authority from the CAG, who is concerned only at the audit stage when the expenditure has already taken place. Consider the following statement. Attorney General of India represent the Government of India in any reference made by the President to the Supreme Court under the Article 143 of the Constitution. Attorney General of India as the highest is the right to speak, vote, and take part in the proceeding of both the houses of the Parliament and joint sitting. Both are incorrect. What? How can you say A is right? The Attorney General of India represents the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution. और सलाह के लिए हाँ बट आर्टिकल 76 है आर्टिकल 76 has provided for the office of the Attorney General for India. He is the highest law officer in country. As the chief law officer of the Government of India, the duties of the AG included to give advice to the Government of India upon such legal matters which are referred to him by the President, to perform such other duties of a legal character that are assigned to him by the President, to discharge the function given on him by the Constitution or any other law. The President has assigned the following duties to the AG: to appear on the behalf of the Government of India in all cases in the Supreme Court in which the Government of India is concerned, to represent the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution, to appear when required by the Government of India in any High Court in any case in which the Government of India is concerned. In the performance of his official duties, the Attorney General has the right of audience in all courts in territory of India. Further, he has the right to speak and take part in proceeding of both the houses of the Parliament or joint sitting and any committee of the Parliament of which he may be named a member, but without a right to vote. He enjoys all the privileges and immunities that are available to the member of the Parliament. Consider the following statements. Article 76 of the Constitution of India provides for the office of the Solicitor General of India. Solicitor General of India enjoys the all privilege and immunities that are available to the member of the Parliament. फर्स्ट तो ऐसे ही गलत है दोनों ही गलत है In addition to the Attorney General, there are other law officers of the Government of India. They are Solicitor General of India and Additional Solicitor General of India. They assist the AG in the fulfillment of his official requirement, responsibilities. Only the office of the AG is created by the Constitution. In other words, Article 76 does not mention about the Solicitor General and Additional Solicitor General. Solicitor General is appointed for a period of 3 years by the Appointment Committee of a Cabinet chaired by the Prime Minister. Solicitor General of India does not enjoy any parliamentary privilege. Consider the following statements. The office of the Advocate General of the state corresponds to the office of the Solicitor General of India. Advocate General is appointed by the President of India. Both are incorrect. The Constitution, Article 165, has provided for the office of Advocate General for the states. He is the highest law officer in the state. Thus, he is corresponds to the Attorney General of India. The Advocate General is appointed by the Governor. He must be a person who is qualified to be appointed a judge of High Court. In other words, he must be a citizen of India. He must have held a judicial office for 10 years or been have an advocate of a High Court for 10 years. He hold office during the pleasure of the governor. Conventionally, he resigned when the government resign or is replaced as he is appointed on its advice. As the chief law officer of the government in the state, the duties of the Advocate General include following: to give advice to the government of the state upon such legal matters which are referred to him by the governor, to perform such other duties of a legal character that are assigned to him by the governor, to discharge the function conferred on him by the constitution or any other law. Which of the following are the not constitutional body? State Public Service Commission, National Commission for Minorities, State Information Commission, National Commission for STs. Which are the not constitutional bodies? STSs के लिए तो कमीशन है लेकिन वो तो कॉन्स्टिट्यूशनल बॉडी है. स्टेट इंफॉर्मेशन कमीशन आंसर और नेशनल कमीशन फॉर माइनॉरिटीज. स्टेट पब्लिक सर्विस कमीशन इज ऑल्सो ए कॉन्स्टिट्यूशनल बॉडी. So 1, 4 is not should be included answer. 2 and 3 is the right answer. State Public Service Commission is a constitutional body. Article 315 to 323 in India, in Part 14 of the Constitution of India, provides for the establishment of the Public Service Commission for the Union of India and a Public Service Commission for each state. The same state of the Article 315 to 323 in Part 14 of the Constitution also deal with the composition, appointments, removal of the members, power, function, and independence of a Public Service Commission. Public Service Commission is in every state is responsible to conduct the examination for the recruitment of to the state services and to advise the governor on disciplinary matters. National Commission for Minority. The Union government set up National Commission on Minorities under the National Commission for Minorities Act 1992. Thus, it is a statutory body. The Commission has following function: evaluate, evaluate the progress of a development of minorities under the Union and the states, monitor the working of the safeguards provided in the Constitution, in law enacted by the Parliament and the state legislature, make recommendation for effective implementation of the safeguards for the protection of the interest of the minorities by the central government or the state government, look into the specific complaints regarding deprivation of rights and safeguards of the minorities and take up such matters with the appropriate authorities. cause study to be undertaken into the problems arising out of any discrimination against the minorities and recommend measures for remove their removal. State Information Commission. Right to Information Act 2005 provides for the creation of the State Information Commission at the state level. The State Information Commission is a high-powered independent body which inter alia, look into the complaints made to it and decide the appeals. It entertained complaints and appeals for pertaining to the offices, financial institution, public sector undertakings, etc. Under the concerned and state government. National Commission for Scheduled Tribes (STs). National Commission for Scheduled Tribes (STs) is a constitutional body in the sense that it is directly established by the Article 338A of the Constitution. The functions of the Commission are to investigate and monitor all matters relating to the constitutional and other legal safeguards for STs and to evaluate their working, to inquiry into specific complaints with respect to the deprivation of the rights and the safeguards of the STs, to participate and advise on the planning process of the socio-economic developments of STs and to evaluate the progress of their development under the union or the state, to represent to present the president annually and at such other times as it may deem fit reports upon the working of those safeguards. With the references to Niti Aayog, consider the following statements. Niti Aayog, it is a extra constitutional body. Governors of the state and the lieutenant governor of the union territories are the members of the governing council of Niti Aayog. The vice chairperson of Niti Aayog enjoys the rank of the cabinet secretary, which are the correct. I think you know about 2 and 3 is the right answer. 1 absolutely. Niti Aayog is a primal policy think tank of the government of the India, providing both directional and policy inputs while designing the strategy, long-term policy, and programs for the government of India. Niti Aayog also provides relevant technical advices to the center and the states. Niti Aayog, like that of the Planning Commission, was created by an executive resolution of the Government of India, Union Cabinet. Hence, it is also neither a constitutional body nor a statutory body. In other words, it is a non-constitutional or extra-constitutional body, not created by the Constitution, not non-statutory, not created by an act of the Parliament. The Governing Council of Niti Aayog comprises the Chief Minister of all states, Chief Minister of Union Territory, with legislature Delhi, Puducherry, Jammu Kashmir, and Lieutenant Governor of the Union Territories. The Vice Chairperson of Niti Aayog is appointed by the Prime Minister of India. He enjoys the rank of the Cabinet Minister. Next question. With reference to the National Human Rights Commission, consider the following statement. NHRC के बारे में पूछा जा रहा है. The chairperson should be a retired Chief Justice of India or a retired Chief Justice of High Court. Chairperson and the members of the NHRC are appointed by the President on the recommendation of the committee headed by the Chief Justice of India. The Commission is not empowered to inquiry into any matter after the expiry of 1 year from the date on which the act constituting a violation of human rights is alleged to have been committed. Only and only three is the right. National Human Rights Commission is a statutory body. It is established in 1993 under the legislation enacted by the Parliament, namely the Protection of Human Rights 1993. Appointment. The Commission is a multi-member body consisting of a chairperson and the five members. The chairperson should be a retired Chief Justice of India or a judge of the Supreme Court, and members should be a serving or retired judge of the Supreme Court, a serving or retired Chief Justice of High Court, and three persons, out of which at least one should be a woman having knowledge or practical experience with respect to human rights. In addition to these full-time members, the Commission also have seven ex officio members. The members chairperson of the National Commission for Minorities, National Commission for SCs, National Commission for STs, National Commission for Women, National Commission for BCs, National Commission for Protection of Child Rights, and the Chief Commissioner of Persons with Disabilities. The chairperson and the members are appointed by the President on the recommendation of a six-member committee consisting of the Prime Minister as its head. The Speaker of the Lok Sabha, the Deputy Chairman of Raj Sabha, and leaders of the opposition in both the houses of the Parliament and the Central Home Minister. Further, a sitting judge of the Supreme Court or a sitting Chief Justice of a High Court can be appointed only after consultation with the Chief Justice of India. The Commission is not empowered to inquiry into any matter after the expiry of 1 year from the date on which the act constituting violation of the human right is alleged to have been committed. In other words, it can look into a matter within 1 year of its occurrence. Which of the following statement is are correct regarding Central Information Commission (CIC)? The Commission has suo motu power, order inquiry into the complaints and appeals pertaining to offices, financial institutions, public sector undertaking, if there are reasonable grounds. The Chief Information Commission hold office for such term as prescribed by the central government until they attain the age of 65 years, whichever is earlier. Leader of opposition in Raj Sabha is a member of the committee which recommends the appointment of a person as a Chief Information Commissioner of the President. तो आपको प्रश्न पूछा जा रहा था सीआईसी के बारे में. तो कमीशन हैज अ suo motu power, order inquiry into the complaints, appeals pertaining to the office, financial institution, public sector undertaking, if there are reasonable grounds. The Chief Information Commissioner hold office for such term as prescribed by the central government or until they attain the age of 65 years, whichever is earlier. The leader of the opposition in the Raj Sabha is a member of the committee with recommendation the appointment of a person a chief information commissioner. चलिए एक और दो राइट है. Central Information Commission was established by the central government in 2005. It was constituted through a official gazette notification under the provisions of the Right to Information Act 2005. The Central Information Commission is a high-powered independent body which inter alia looks into the complaints met to it and decide the appeals. It entertains complaints and appeals pertaining to the offices, financial institution, public sector undertaking under the central government, the union territories. The commission can order inquiry into any matter if there are reasonable grounds of suo motu power. The commission consists of a chief information commissioner and not more than 10 information commissioners. The commission, when constituted initially, had a five commissioner, including the chief information commissioner. They are appointed by the president on the recommendation of the committee consisting of the prime minister as a chairperson, leader of opposition in the Lok Sabha, and union cabinet minister nominated by the prime minister. The chief information commissioner and the information commissioner shall hold office for such term as prescribed by the central government or until they attain the age of 65 years, whichever is earlier. They are not eligible for reappointment. With the reference to the Central Vigilance Commission CBC, consider the following statements. It is neither a constitutional body nor a statutory body. It looks into the complaints which are declared as an office under the Prevention of Corruption Act 1988. Central Vigilance Commissioner hold the office for a term of 5 years or until they attain the age of 65 years, whichever is earlier, which is the above statement is correct. Only B. 2. Central Vigilance Commission CBC is the main agency for preventing corruption in the central government. It was established by in 1964 by an executive resolution of the central government. Its establishment was recommended by the Santhanam Committee on the Prevention of Corruption. Originally, the CBC was neither a constitutional body nor a statutory body. Later, in 2003, the Parliament enacted a law conferring statutory status on CBC. The function of the Central Vigilance Commission (CVC) is to inquiry or cause or inquiry or investigation to be conducted on a reference made by the central government wherein it is alleged that a public servant being an employee of the central government or its authorities has committed an offence under the Prevention of Corruption Act 1988. The CVC is a multi-member body consisting of central vigilance commissioners and not more than two vigilance commissioners. They are appointed by the president by warrant under his hand and seal on the recommendation of a three-member committee consisting the prime minister as its head, the union minister of home affairs and the leader of opposition in the Lok Sabha. They hold office for a term of 4 years or until they attain the age of 65 years, whichever is earlier. After their tenure, they are not eligible for further employment under the central or the state government. Which of the following statement is are correct regarding the Central Bureau of Investigation (CBI)? It operates under the Ministry of Home Affairs. CBI investigates crime of corruption, economic offences, terrorism, serious and organized crime. It derives its empower of power from the Delhi Special Police Establishment Act 1946. चलिए इसका सही जवाब है केवल और केवल तीन सही है सी इज द राइट आंसर Central Bureau of Investigation CBI was set up in 1963 by a resolution of the Ministry of Home Affairs. Later it was transferred back to the Ministry of Personnel and now it enjoys the status of an attached office. The establishment of CBI was recommended by the Santhanam Committee on the Prevention of Corruption 1962-1964. The CBI is not a statutory body. It derives its power from the Delhi Special Police Establishment Act 1946. The CBI is the main investigating agency of the central government. It plays an important role in the prevention of the corruption and maintaining the integrity in the administration. It also provides assistance to the Central Vigilance Commissioner and Lokpal. CBI investigates the crime of corruption, economic offences, serious and organized crime other than terrorism. The NIA has constituted after the Mumbai terror attack in 2008 mainly for investigation of incident of terrorist attack, funding of terrorism and other terror related crime. With the reference to the Lokpal and Lokayukt Act 2013, which of the following statement is are correct? The jurisdiction of the jurisdiction of the Lokpal includes the Prime Minister of India. Lokpal has a suo motu power to proceed against any public servant. Institutions which are aided by the government are excluded from the purview of Lokpal. Yes, 1 2 and 1 3 1 3. Who matter? Silent feature of Lokpal and Lokayukt Act 2013 as follows. It seeks to establish the institution of Lokpal at the center and the Lokayukt at the level of the state and thus seek to provide a uniform vigilance and anti-corruption roadmap for the nation, both the center and the states. The jurisdiction of the Lokpal includes Prime Minister, ministers, Minister of Member of Parliament, and a group A, B, C, D officers and officials of the central government. The Lokpal of consists of a chairperson with a maximum of 8 members, of which 50% shall be a judicial member. 50% of the members of the Lokpal shall come from among us SC, STs, OBC, minorities, and women. Incorporates provisions for the attachment and confiscation of the property of the public servant acquired by corrupt means, even while the prosecution is pending. It's laid down clear timelines for preliminary inquiry. It is 3 months extended by the 3 months for investigation. It is 6 months which may be extended by the 6 months at a time. For trial, it is 1 year extendable by 1 year and to achieve this special court to be set up. Institutions which are financed fully or partly by the government are under the jurisdiction of Lokpal, but institutions aided by government are excluded. It provides adequate protection for honest and upright the public servants. Lokpal conferred with the power to grant sanction for prosecution of the public servant in place of the government or competent authority. The following are the shortcomings of the Lokpal and Lokayuks Act. Lokpal cannot suo motu proceed against any public servant. Emphasis on form of complaint rather than substance. Heavy punishment for the false and the frivolous complaint against a public servant may deter complaints being filed to the Lokpal. Anonymous complaints not allowed. It can't just make a complaint on plain paper and drop it in the box with the supporting document. Limitation period of 7 years to file a complaint. Thank you.